Welcome back to FDVN channel, where we share current legal issues, provide legal English lessons, and connect to build our English skills in the legal field. Today, we continue with the vocabulary lesson. However, unlike in the previous videos, through this video, we will learn the vocabulary through verdict. The name of judgment, United States v. Johns Manville Corporation, 231 F. Sup. 690. We come to the first part, Summary of Judgment, United States v. Johns Manville Corporation, 231 F. Sup. 690, was a landmark lawsuit concerning violations of occupational safety and health regulations, particularly related to the production and use of asbestos, a hazardous material. The plaintiff was the United States government, and the defendant was Johns Manville Corporation, a prominent asbestos manufacturer. The lawsuit stemmed from allegations that Johns Manville failed to comply with safety and health regulations designed to protect workers from the dangers of asbestos exposure. Asbestos, a common material in the construction industry, is known to cause cancer and other serious respiratory diseases upon prolonged exposure. The government alleged that the company had failed to implement adequate safeguards for workers handling asbestos, putting their health at significant risk. Specifically, the government accused Johns Manville of violating the U.S. Department of Labor's occupational safety and health standards, which outlined requirements for controlling the work environment and protecting workers from hazardous substances, including asbestos. The court found in favor of the government, ruling that Johns Manville Corporation had indeed violated safety regulations. As a result, the court ordered the company to take specific remedial actions, including improving working conditions for employees and implementing measures to reduce asbestos exposure. The court's decision mandated that the company overhaul its operations to comply with safety standards and protect workers from asbestos-related diseases. This case is considered a pivotal moment in the history of worker health and safety in the United States. Remember to take note the vocabulary showing in the video. If it runs too fast, you can pause to write down. Now to the second part, the main contents of judgment. April 16, 1964, it is ordered that the motion of defendant Robert R. Porter for judgment of acquittal on all counts is granted, and the motions of defendants Robert F. Orth, Johns Manville Corporation, and Keesby Madison Company for judgment of acquittal are denied as to count 1 and granted as to counts 2 and 3, Part A. Of order, see document 179, being Memorandum of Rulings on Objections to Exhibits offered against Defendant Porter dated April 9, 1964, Part B, of order, count 1, the evidence justifies a finding that the corporate defendants, during the period from 1954 to 1959, arranged for meetings of their subordinate employees to achieve uniformity in their price lists. Note testimony that the purpose of the first meeting was to make prices uniform by raising KM prices about 5% and JM was to bring their prices up, accordingly. N 3033. After the meetings, the vice president of KM approved the resultant price lists with minor changes, if any. Deviations from the price lists involving reductions were discussed between representatives of the companies and usually approved if not substantial. The list prices of the corporate defendants remained substantially identical until the date of the indictment, by the year 1958. The volume of AC, asbestos cement, pipe imported from Europe was such as to cause both corporate defendants concern and their competition with it was vigorous. They expressed the desire to prevent it from securing a foothold in this country. At meetings in Europe, 1959 and 1960, defendant Orth, a vice president of Johns Manville 697 in charge of pipe sales, complained of the unstabilizing effect of sales of European AC pipe on the prices in the United States and the importance of stabilizing such prices. At these meetings, the restriction of imports of European AC pipe to a definite amount were discussed and efforts were made by defendant Orth to secure some restrictions on imports and price stabilization. The jury may consider this evidence in its case against Keesby Madison, its sole stockholder being Turner Newell, Limited, at least in connection with the efforts by Mr. Orth to secure agreement of the European importers to stabilization of prices and restriction of imports, in June 1959, Mr. Costa testified that at a meeting in Brussels, attended by Mr. Colton, Vice President of Johns Manville International, Mr. Colton stated that Mr. Orth would come to Europe to discuss exports of AC pipe from Europe to the United States with the European manufacturers of AC pipe present at that meeting. On the evening of this meeting, Mr. Costa saw Mr. Colton in the presence of Mr. Bateman, managing partner of Turner Newell, Limited, which owned all the stock of Keasby Madison Company, in the hotel lobby. Mr. Costa testified at NE 7941 concerning the Paris meeting of March 1960. We raised the question, even supposing that we make an arrangement with Johns Manville, what about Keasby Madison? In other words, if they do their own selling policy, what is the use of finding any arrangement whatsoever? And I remember Mr. Orth saying that we should not have worried about it, because he would have gone to London to see Turner and Newell on the subjects of Keasby Madison, or something like that. I don't remember when he said, when, or tomorrow or within a week, or that I don't remember. Mr. Coons testified at NE 9338 to 9340 that Mr. Orth had stated at the March 1960 Paris meeting that he had the permission to make agreements for and on behalf of Keasby Madison, vis-a-vis Turner Newell, who were in London. Mr. Orth stated that he had seen Mr. Suthill, one of the top managers of Turner Newell, Limited, in London. The day following this Paris meeting, Mr. Orth said he was returning to London. On cross-examination, Mr. Coons testified that he does not believe Mr. Orth mentioned Keasby Madison by name at the Paris meeting of March 1960. The activities of Mr. Orth at the European meetings were in furtherance of the ends and aims of the conspiracy in which the jury may find Keasby Madison had been participating since 1954. There is sufficient evidence, of the type described above, in the record from which a jury may find beyond a reasonable doubt a single, common plan, design and scheme constituting one conspiracy, rather than several. It is noted that in Blumenthal the court found that the jury might find two separate agreements between different parties, some parties being common to each agreement, could be steps in the formation of a larger, ultimate 698 and more general conspiracy. On this record, there is sufficient evidence to justify the jury in finding that the activities of the corporate defendants from 1954 to 1958 in pricing and the activities of Mr. Orth in the same pricing field, as well as in his alleged efforts to restrict imports by allocation agreements or otherwise, were all directed to achieving a single unlawful end or result of unreasonably restraining trade and commerce. Defendant Johns Manville Corporation moves for judgment of acquittal on the ground that the government has introduced no evidence to establish liability of Johns Manville Corporation, as distinguished from its subsidiaries, Johns Manville Sales Corporation, Johns Manville Products Corporation, and Johns Manville Products Corporation of California. The motion, insofar as it is based on this argument, must be denied. There is sufficient evidence for the jury to find beyond a reasonable doubt either or both of the following. 1. The corporate existence of the subsidiaries apart from the parent was mere form and the agents of the subsidiaries acted as agents for the parent, all of the corporations being one unitary enterprise. 2. The subsidiaries were agents of the parent, and the employees of the subsidiaries acted as subagents of the parent corporation. The government has not established that the American Society for Testing and Materials and the American Waterworks Association are co-conspirators or that they had knowledge of the conspiracy. Hence, the jury will be instructed to disregard Section 7, B, and C, of the indictment, Document 1, which shall be considered as having been deleted therefrom, Part B, of Order, Count 2, under the decision in American Tobacco Company v. United States, 328 U.S. 781. 784 to 786, 66s. CT 1125, 1127, 90L, ed. 1575, 1946. The government is required under Count 2 of the indictment to submit evidence which establishes beyond a reasonable doubt that defendants have conspired to acquire or maintain the power to control and dominate interstate trade and commerce in a commodity to such an extent that they are able, as a group, to exclude actual or potential competitors from the field, accompanied with the intention and purpose to exercise such power. At page 809, 66s. CT at 1138 to 1139, the court said, A correct interpretation of the statute and of the authorities makes it the crime of monopolizing, under Section 2 of the Sherman Act, for parties, as in these cases, to combine or conspire to acquire or maintain the power to exclude competitors from any part of the trade or commerce among the several states or with foreign nations. 699 provided they also have such a power that they are able, as a group, to exclude actual or potential competition from the field, and provided that they have the intent and purpose to exercise that power. There is no evidence in this case from which the jury could find beyond a reasonable doubt that the defendants conspired to acquire or maintain power to raise prices or exclude competition in the relevant market. Although the indictment alleges that the trade or commerce involved is asbestos cement pipe and couplings, the evidence shows that the primary competitors for each of the corporate defendants were the sellers of metal pipe. For example, the 1960 Business Condition Report of Johns Manville's Los Angeles Pipe District Office states concerning the outlook for 1961, "The competition is going to be tougher than we have yet experienced, both foreign and domestic, in AC as well as metal pipes." At page 3 of this report, it is stated, "The steel pipe competitors have been even more aggressive than in the past." The record is also replete with testimony concerning sales of concrete pipe, tile pipe, plastic pipe, clay pipe, steel and wood pipe, even though the only evidence of economic power in the field relates to the volume of asbestos cement pipe sold by defendants. There is every indication in this record that the above types of pipe were reasonably interchangeable by consumers for the same purposes, except in certain soils such as are present in southwest Texas. Even in such soils, plastic, tile and concrete pipe were used. In the DuPont case, Supra, the court said at page 394. 76s.ct at page 1006 to 1007, but where there are market alternatives that buyers may readily use for their purposes, illegal monopoly does not exist merely because the product said to be monopolized differs from others. The power of defendants to raise prices and to exclude competition might be negligible if the total sale of these apparently interchangeable products were substantially in excess of the sales of asbestos cement pipe. The government has clearly not sustained its burden of proof on this element of the crime charged in count 2. In its oral argument, the government took the position that the language of footnote 23 on page 395, 76s CT on page 1007 of the DuPont case, Supra, made proof of the relevant market immaterial on a charge of conspiracy to monopolize pursuant to 15 U.S.C. Section 2. Apparently, the government takes the position adopted in Lessig v. Tidewater Oil Company, where language used at 474 to 475 was qualified on rehearing. However, the language in the above-mentioned footnote only states that the scope of the market was not an issue in Story Parchment Company v. Patterson Parchment Paper Company. An examination of that case indicates that neither counsel or the court considered the issue of what was the relevant market, and that the parties conceded, apparently, that interstate trade and commerce in vegetable parchment paper was a sufficient description of that market. To adopt the government's position would be to disregard the approach of the above-cited decisions of the United States Supreme 700 Court and the language concerning relevant market in such recent decisions as International Boxing Club of New York v. United States. Part B, of Order, Count 3, the absence of evidence to prove beyond a reasonable doubt the existence of a relevant market of the type of trade and commerce alleged in the indictment, as discussed under Count 2 above, requires a grant of judgment of acquittal under Count 3. The evidence produced by the government indicates that the fact that several types of pipe other than asbestos cement pipe were actively competing with it may have had a controlling effect on the power to raise prices and to exclude competition. In American Tobacco Company v. United States, Supra, the Supreme Court of the United States quoted with approval the following language from the trial court's charge. The phrase "attempt to monopolize" means the employment of methods, means and practices which would, if successful, accomplish monopolization, and which, though falling short, nevertheless approach so close as to create a dangerous probability of it, which methods, means and practices are so employed by the members of and pursuant to a combination or conspiracy formed for the purpose of such accomplishment. This language was based on previous statements of the Supreme Court of the United States over many years, requiring not only intent but a consequent dangerous probability of the accomplishment of that intent. Swift and Company versus United States. More recent federal cases have stated that an attempt to monopolize means the employment of methods and practices which are utilized for the specific purpose and with the specific intent to achieve or build a monopoly, and which, if successful, would be likely to accomplish such monopolization. Such cases have discussed the relevant market and considered whether the evidence could establish beyond a reasonable doubt that the defendant's activities would be likely to accomplish monopolization. There is no proof in this record which would justify the jury in finding beyond a reasonable doubt that the activities and plans of the defendants, if successful, would be likely to accomplish monopolization, in view of the absence of any evidence concerning the relationship of competing pipes to the relevant market. Footnote 23 of the DuPont case, Supra, does no more than point out that certain cases cited there were distinguishable because they involved attempts to monopolize, rather than the question of monopolization, which was before the court in the DuPont case. At the end of the footnote, the court considered United States versus Aluminum Company of America, because it did involve the question of monopolization, and pointed out that the court did make a finding in that case of the relevant market. There is no statement in the footnote that, in a case involving a charge of attempt to monopolize under 15 U.S.C. Section 2, the government may produce evidence which concerns only the product of two manufacturers where this same evidence shows active competition and interchangeability between that product and several other similar products. The ability to raise the price of this product, asbestos cement pipe, may well depend upon the activities of competitors producing the competing product. And the ability to exclude foreign competition in this product may also be affected by the activities of such competitors producing other types of pipe. The factual background of the Lessig case, Supra, makes the 701 above-mentioned language in that case inapplicable to this record. Also, it is noted that the Lessig case, Supra, was a civil case, where the plaintiff's burden is not as great as that of the government, which must establish every element of its case beyond a reasonable doubt, and that is the content of the judgment. Now we come to the part of boosting the vocabulary we have learned. First, collection of some specialized vocabulary from the above judgment: a landmark lawsuit, allegation, allege, authorities, cross-examination, defendant, justify, liability, memorandum of rulings, occupational safety and health regulations, on behalf of, plaintiff, record, remedial actions, testify, testimony, the jury, the statute, the trial court's charge. Second, some expand vocabulary about occupational safety and hygiene regulations, accident prevention, chemical safety, construction safety, emergency response, hazardous materials, labor safety, occupational hazard, occupational safety and health, risk assessment, safety awareness, safety equipment, safety guidelines, safety inspection, safety measures, workplace safety. And that is the end of the lesson today. If you have any further question, please comment below this video or send your consideration to our email. Remember to subscribe, like and share this video if you find it helpful. Thank you for watching and see you in the next video.